Crypto fans, how are we? I'm CRYPTOMAXX. This is CRYPTOMAXX News. And wait until you see what's going on. This case will go down as one of the craziest cases in SEC history because they have botched things so badly. And I want to tell you, they took on the wrong company because Ripple is absolutely knocking it out of the park on the defense side. So great job. They need, when this is all over, they should all get a big thanks from everybody in the XRP community because I'm confident they're gonna either win or settle, and it just depends on what's best for Ripple and XRP at that point. But anyway, we're going over some good stuff. I am a new channel. I appreciate your support. I'm always going to dig behind the scenes. I want to tell you basically what I did today is I went through and I'm going to give you my layman's view. I'm not an attorney, but I'm going to give you my layman's breakdown of all the key points in Ripple's response to the deliberative process privilege documents that the SEC doesn't want them, to get out, basically. So that's called an in-camera review by Judge Netburn. So everything I do here, though, not financial advice. I'm not an attorney. I'm not telling you anything other than good educational stuff. But I want to tell you this. Wow. I had no idea. There is a bombshell in this one today. And I had no idea until I went over it. So, you know what? I'm going to skip because I just want to go right to it. I'm going to skip going over. The market's kind of funky. You guys all know that. If you're not, I check my phone like every 10 minutes to see where the market's at. So, anyway, like, subscribe, follow. You get a commitment back from me if you do, and I appreciate your support. Let me go on to, where is it? Okay, so today was Ripple defendants' opposition to the SEC's opposition to the judge being able to see all this information. Anyway, crazy. Judge had already ruled on it that they were supposed to give up these documents, and then they came through with this opposition piece on the 14th. That was right here. And then now Ripple is doing their version of, hey, here's why you should be looking at this, judge, right? So the judge has already seen it, but now the judge gets to decide based on the arguments what can be used, I guess, as evidence. Again, I'm not an attorney, so I don't know that stuff, but I don't know the lingo. But I'm going to give you the laydown of what it's so crazy. Wait until you see some of this stuff. Okay, so here's just the key points that I pulled out that I thought were relevant. And I'm going to blow this up a little bit so you can kind of follow along with me. And all I did is I took, where is it? Right here. I took this document. What page is that? This is all the appendix. Another crazy thing going on here in the appendix. But I took this document, I went through it, and I cut out the pieces that I thought from, hey, just a normal everyday person, what would I be interested in? And hopefully it is valuable to you. And then this stuff I'll probably even take as another day to go over it because there's some cool stuff in there. Really cool. All right. Sorry about that. That's my OBS program. If anybody knows how to get OBS to show proper color for whatever reasons, there's things that don't show the way my screen does. So if you know of that little glitch, that would really help me. All right, so the court did not invite the SEC to re-litigate the issues decided on the April 6th hearing. So basically, in this little section, they're going back and saying, hey, no, SEC, you don't get to try to retry why you don't get to give the docs that the judge already said you had to give. That's what that one's about. SEC also raises two new points of relevance that they can't, that can be readily disposed. And then they kind of break down these pieces. The bold ones are the ones that it's just awesome. Many of these documents appear to not only be highly relevant but potentially exculpatory in that they bear on what the SEC was hearing and discussing regarding the market's interpretation and understanding of the application of federal security laws to Bitcoin, Ether, and XRP. And this is coming up here at the end. Just blow your mind stuff, right? Okay. Yeah, exculpatory. That my understanding of exculpatory has always been like evidence that would lead to believe that you're not guilty, right? Or you're, in this case that would work against the prosecution's case. Okay. Consistent with the court's findings, these materials are clear and relevant. I don't know what scienter means, but this was the piece that I kind of caught on to. These things are relevant to the fair notice defense and also the analysis under Howey. And if you looked at my Howey upload this week, then you'll know how big Howey is too. So there's a few different ways that Ripple can win this thing. And the SEC is showing equally weak in every different category. But I mean, if anything, we get to wait and watch and see the SEC just fall on their face all the time, which is basically what's happening. As the court has recognized, DPP in particular cannot be used to prevent the disclosure of critical information because it is a qualifying privilege. It's not like attorney-client privilege. Just means that they have to have a standard in which it could be applied. It's just not across the board. Well, the SEC is trying to use it, as you can see here. The SEC portrays the right to withhold deliberative documents in a broad, sweeping terms, effectively claiming a privilege over any internal document or communication that touches on the regulation of securities or non-securities that the SEC might at some point seek to regulate. So not just today, but if they want to come back or potentially even go get somebody else, right, on something. They're trying to use this broad brush and just paint everything as deliberative process privilege, which means that we get to hold it, you can't see it. Okay? That's not the government I want in my country. I just don't. They can hold stuff that they know is exculpatory, and in some cases they can get away with it. Just imagine if this was you and me. What would happen, right? So another thing that I'm just not happy about, the way that they've gone about it is so dirty. So, all right, this section, to fall within deliberative process privilege, materials must bear on the formulation or exercise of the agency policy-oriented judgment. The SEC has never asserted, oh yes, I love this, never asserted that it commenced a policy process addressing whether to regulate digital assets as securities. So just in my opinion, that just says, hey, since you never said it was, how can you claim privilege? Right? Doesn't make any sense. So they kind of hit on that. I love that part of it. And this part right here, even though it's more complicated, but what they're saying is even if there is a piece that the judge said could be deliberative process privilege and Ripple doesn't get to see, they have the right to see the other pieces in and around those facts that aren't privileged, meaning that they could glean something from the in a sense, like if you were to redact something and black it out, they could glean from the rest of the paragraph, right, as you would read some legal document and go, right? So I love this part because they're attacking everything. They're not leaving anything on the table. So, here's the bombshell right here. Let me go over this first. The SEC now asserts that 9 of these sets are subject to another previously unasserted privilege. Oh, they're trying to, in a sense, claim attorney-client privilege type. Basically, they came back and made another argument. And I don't think that one's going to fly. If it did, I'd be shocked. But They're now, after the fact, because they lost the DPP portion to the judge, right, saying, hey, you have to give up the documents. Now they're coming back and saying, oh, no, it's attorney-client. You can't do that. So, and they've passed the deadline, and there's a bunch of stuff in there, but I thought it was okay. William Hinman speech, June 14th, 2018. On June 13th, 2018, an XRP memo was circulated, right? Perhaps the most explosive revelation of the SEC's privilege log is that the SEC Division of Corporate Finance, which is Hinman's division, a division that operates distinctly from the Division of Enforcement, wrote a memorandum containing a legal analysis of XRP. The memorandum was then circulated to certain individuals at the SEC on the day before former Director of Corporation Finance, Bill Hinman, right there, gave the speech publicly declaring that Ether was not a security, right? And there are a couple different ways they come back and get him on this, and it's so beautiful because, again, I need to go over that other piece. Hang on one second. I'll stop right here and go over it. Let me find it first. It's right here. There it is. Okay. So here is... So we know that the Hinman speech was supposed to be his personal opinion, right? This was not the SEC. It's my personal opinion. Over and over, like a broken record. That's all we heard, right? So take a look at this. First off, there's 3 of these little privilege logs that they don't want out. And they played dirty pool and didn't include them. And then now that the Ripple defense has come back and said, hey, you've got to put these in. We thought you were putting them in. And so I think they pulled a fast one, and then I think it's going to work against them again because they pull this crap all the time. But they had 2 high-level law firm discussions that they don't want anybody to know about. And then here it is. The third is an email chain concerning discussions with a third party whom defendants understand received guidance from the SEC to analyze its digital asset under the framework set forth in the William Hinman June 14th, 2018 speech. You remember the one that was personal opinion? Not according to this. You're using it to direct and guide a third party on how to evaluate its asset. And you want to keep that out of the court case. Is that the government that we want? I mean, I don't even want to get political, but honestly, that's disgusting. These people, it's just absolutely mind-blowing. If that turns out to be as big as it seems like it is in this document, this email could blow this thing absolutely out of the water, because we know if Ether is considered a non-security, there is no way when you match Ethereum and XRP or the XRP ledger that you could get anything different. Ethereum did an ICO, an initial coin offering. They raised funds to build their network. They have the CEO on camera saying we're raising funds to build the network. It's unbelievable, the dirty pool that they have played. And I think everything ties back into the Hinman speech, the consensus meeting. There is so much here. I'm going to do a 2-parter because it's that big. And then let me get back to where I was. Right here. Okay. Man, this blows me away. The day before they have this speech. Now, there's a lot of other things, but there was a section in the Hinman deposition where, if you remember, they deleted a file, and they caught him deleting a file. And it was by a guy named Seaman, I believe was his last name. And he's in the Appendix A the memo pieces in there, and it's amazing. So you end up getting the day before this all happens, the big speech, June 13th, XRP memo is circulated, and they don't want you to see what it said. This is, you got to be kidding me. Unbelievable. They don't tell us who authored the document and when it was originally authored. But it was circulated the day before the speech. No such thing as coincidence here. There's a reason they did that on the 13th, and the 14th it happened, right? The speech happened. So further documents produced by the SEC show yet another division. Oh, yeah. The lady's name I can't pronounce. The Division of Investment Management. I'll show you her name here in a minute. They were assessing facts in relation to Bitcoin, Ether, and XRP. Now, keep in mind, they have admitted, right, that during all this time, they never once told a third party ever that XRP was a security until they filed the lawsuit. Right? So, then this is the part where Brad Garlinghouse meets with the SEC. And if you remember, this is so funny with the Gensler thing. He said, come in and talk to us and sit down and we'll determine whether or not. That's exactly what Brad Garlinghouse did. He went in, he sat down, he talked to him, and then Clayton basically encouraged them, encouraged the Ripple executives to continue the ongoing discussions with staff of the Division of Corporate Finance. Just continue. Not one time it mentioned any enforcement or ongoing enforcement. Okay? So, I'll show you what I'll go over. I'll do this tomorrow. Here's the gal's name. You can see why I can't pronounce it. I didn't even come close. But anyway, she is I believe she's the director of that other division inside the SEC. And the things that go on, even in this one, let me at least find this guy's name here. Hang on, let me see if I can find it. Mr. Seaman, where is he? Michael Seaman, right here. He is mentioned first off, he deleted the file that was mentioned, and they caught him. If you remember in the Hinman deposition, they caught him, and their attorney about had a heart attack, right? He about dropped to the floor. You could tell he's like, what? So again, I think that's in when I did my review of that, the night it came out, I would have loved to have been a fly on the wall in that deposition, because I bet the attorney's face just dropped to the floor. He's, heart pounding, because they knew they found a file and they found it in the metadata. So anyway, I'm going to stop right there. I was excited to bring this to you for those of you who followed me over from TikTok. They're just anything SEC now. If it has anything SEC, they're just blocking from me putting it out there. And then it'll come out hours later. They'll suppress it. They won't put it on the page. I mean, it'll be suppressed basically. So thanks for following me. Hey, like, subscribe, follow. I'm CryptoMaxx. I'll be back tomorrow.